being provided. So as Kayla mentioned, I was at the Nebraska Office of Public Guardian prior to this, and then I started in December of 2019. And that was to start the office, get it up and running, to serve clients. Originally, this legislation for our office was established in 2016, but there was no funding for it. So it wasn't until summer of 2019 that the Office of Public Guardianship Commission was able to convince the General Assembly to provide some funding for our office. So that's when I started. Because of that funding shift with the 2019 legislation, it kind of focused the program, the pilot program, to just serve residents of the 2nd Judicial District, also known as Denver County. Originally, we were supposed to also serve in 3 other districts, but just didn't obtain the funding to be able to start that. So our office actually started taking clients in April of 2020. And if you recall, March of 2020 was when COVID-19 pandemic was kind of defined and established. So it took a long time for us to actually go through the court process and be appointed. And we'll talk about the court process. So our first client that we were finally appointed to serve as their guardian was August of 2020. So we're coming up onto our anniversary.
Sophia, can I ask you, one of the questions that's been raised is, why are only adults allowed to be wards?
Oh, so it's just our program, the legislation is focused on adults. So there is a legal guardianship process for minors, but that's a separate process, and it's because the commission, the General Assembly, they all decided this program would serve adults only.
Thank you.
Yeah. Okay. So, all right. So yeah. So part of also the barrier to us getting appointed until August was the pandemic not only hit, and people were then, of course, not discharging or moving people really out of hospitals and into facilities or other community places, but also the court, the Denver, well, all the Colorado courts, but particularly we appear in Denver County Probate Court. They had mandates from the Chief Justice that said you can only hear emergency guardianship cases and some of these emergency issues. So at the time, we were only accepting nominations for permanent guardians. So a lot of our cases were filed in April and May, and then kind of on hold until the court opened back up. And that was, I think, July, mid-July, when courts sort of opened back up to handle permanent guardianship cases. And then we were appointed in August. So with our office launching in April of 2020, we started with myself, 4 public guardians, and a staff assistant. The public guardians each have a caseload of approximately 20 clients, and the cases are weighted. So we have some really complex cases that maybe take a lot of guardian time. So they may not have 20 clients. While they have that case, they may have 18 or 19. It just depends. The 20 clients per guardian caseload is a national best practice standard through the National Guardianship Association. And we'll talk about the NGA later. One exciting piece for us is that in July, we're adding another public guardian. And this is made possible by additional funding directly from the Office of Behavioral Health to serve clients at the mental health institutes that are ready to discharge back into the community through that Momentum program. So I'm really excited for that. We're interviewing this week, and I hope to have someone hired by the end of June. So one of the things I hadn't mentioned quite yet, but it's on the slide, is this director report to the General Assembly. So not just starting at the office, but also the General Assembly said, hey, pilot program, we want you to collect all this data and tell us in early 2023 whether this program should continue, should expand, should discontinue, or if there should be some other nonprofit established to run the Colorado Office of Public Guardianship. So I will talk more in depth about the director report and information that goes into that report, and also how ways that possibly you all can help us with reporting that data back to the General Assembly. So first, I want to talk a little bit more specifically about guardianship and what that looks like here in Colorado, and discuss some alternatives. So guardianship itself is a court process where an individual is deemed incapacitated by the court at a hearing, a full evidentiary hearing. And at that court hearing, the court will receive medical documentation, medical opinion as to whether the individual is incapacitated. So can that individual make their own medical legal decisions? Do they understand the depth of their medical conditions, and can they make appropriate decisions for their health and safety and welfare? So if the judge receives information and deems that person incapacitated, then the second step for the court is to say, okay, do they need a guardian to help make these legal decisions? And if they do, who do we appoint? So in our case, of course, when a case is filed, you're nominating our office to serve as guardian. And so we become guardian only once the court has determined that an individual is incapacitated. That is not a decision our office makes. We have to obtain information that ensures that they're incapacitated, because we won't say, go ahead and nominate us if we think a person isn't qualified for guardianship. So maybe there's a less restrictive alternative that could serve this person that we're willing to assist in kind of, hooking up with services or giving some suggestions. But one of the things that I've learned about guardianship, and I'm sure you're all aware, is it's a real civil liberties issue, right? So you're basically taking someone's rights away to make these legal decisions on their behalf. And so I feel, and I think most people feel, guardianship should be a last resort. So have we tried all these other things? Are we certain this person is incapacitated? Because I do not want our office coming in and, becoming guardian for someone who we don't think is incapacitated, who doesn't need a guardianship, because it is a significant legal matter. So if the court finds that person's incapacitated, the court appoints our office, or any guardian for that matter. The court will sign papers. So there'll be legal paperwork that's an order of appointing guardian, and then there's letters for a guardianship. So the order will tell you very specifically what authority the guardian has to make decisions on behalf of the incapacitated individual. A lot of times, courts, not just in Colorado, it's been my experience in Nebraska as well, will automatically go to a full guardianship. That means basically the guardian has all this power or authority to make all kinds of decisions. And we'll kind of talk through some of those areas that we can make decisions about for the individual. But sometimes there could be less restrictive alternatives. And so sometimes a limited guardianship could be appropriate. Maybe someone can't make certain legal decisions about their medical status, but maybe they have capacity to make decisions about where they want to live. And so the court would specifically say, guardian, you can make these medical decisions, but the ward, we call them our client. I don't like ward, but that's the legal term. Our client can make their own decisions regarding where they're going to live. So just because someone is deemed incapacitated doesn't necessarily mean that they have no ability to make any other decisions. You know, and that's something that as we talk through our process to you on how we are guardian with someone, we want to make sure that, you know, whatever decisions they have the capacity to make, they're making those decisions. We're not just overrunning their lives and making all these decisions without them or knowing what they would want to have happen. So some other alternatives, I mentioned a limited guardianship. Some other alternatives, if someone isn't, you know, fully incapacitated and can handle some of these decisions on their own, would be maybe they're having issues with their finances. Maybe they're easily exploited financially or something like that. Well, maybe that's a situation where they need a Social Security Administration representative payee. So that's someone who, you know, has the authority to have an account on behalf of this person, and can help pay their bills, can give them, you know, their funds for buying things, but it's structured in a way that the person that's incapacitated doesn't have full access to all their money, so that they can't just give it away. I know that's one thing that a lot of our clients like to do. They like to give their money away. And, you know, we say, no, you've got to have money for your housing. You got to have money for groceries, you know, but they either don't have the capacity to understand how that works, or they're easily exploited by others. In the same lines of that would be a Veterans Affairs fiduciary. So it works the same way, or similarly, I shouldn't say the same, similarly to a Social Security rep payee, but it has to go through the VA process, which is very long and difficult. But basically a fiduciary then handles the money and then helps that person with their accounting. Something else that we talk about as far as alternatives, that these alternatives, advanced directives, those have to be put in place prior to someone becoming incapacitated. So, and I'm sure all of you are aware, it's better, you know, to have some advanced directives in place so that someone knows your desires and wishes on how, you know, you want to receive certain medical treatment. But you have to have capacity when you complete those. So it's one of those kind of preventive things, as far as if someone has to be appointed as your guardian, at least at that point, they know your wishes and desires if you're unable to express those to your guardian. Another kind of pre-planning would be having a will and naming someone through your will that you want to serve as your guardian. That's, again, you have capacity, you're able to name that person's able to confirm that they would be your guardian. You know, I think we can all agree it would be, in most cases, better to have someone who's familiar with you to be your guardian than a stranger. And right now, that's how our office is as last resort. We're strangers to you. So we have to, you know, really learn how to learn about our person and what they would want. So talking about our services. So once we're granted authority as a guardian by the court, and those authorities are statutory based. So we can, if the court gives us the authority to, we can make those legal decisions about housing or where they're placed. We can obtain and maintain state and federal benefits for our clients. We can make decisions regarding medical treatment, other kinds of care and treatment. So, you know, if they need to go to the eye doctor, if they need to see a specialist, we can help make those decisions. As I mentioned already, we do delegate some of the decision making to our client. That depends again on their capacity level and what's important to them. And then as I mentioned, the least restrictive alternatives, that's something that as we meet someone, as we work with someone, we're always looking at least restrictive. So as say we have a client who is in a mental health institute at Fort Logan, Is that the best place for them? Are they ready to discharge? Can we find them a less restrictive, less institutionalized placement? So we're always looking at that. We're also always looking at person-centered or person-directed planning. So again, we meet with our client, we interact with them, we ask questions, we do all kinds of things to learn about our person so that we can know what their desires are, but also including them. What are your goals? Like what do you want to have to be able to have a better quality of life? One thing our office does not do are any of the finances. And I don't know if that will change at any point in the future if our program is expanded. But we don't do conservatorships. And we don't become rep payee or VA fiduciary. Our office is just simply not set up for it right now as a pilot program. We do contract with Colorado Fund for people with disabilities to become Social Security rep payee or VA fiduciary for our clients if that's necessary. Also, some facilities are able to be rep payee as well. And so that is something that we work with our client on to figure out who should be rep payee. Sometimes our clients already have a rep payee through other organizations or entities. We don't automatically change it just because we become guardian. We'll work with that rep payee and make sure that they're appropriate for our clients. So I do want to talk a little bit about limitations to guardianship. I think a lot of times the impression is that, well, once a guardian's in place, there won't be any more issues or concerns, for the individual. And that's not true. So something that we struggle with as well as guardians is, everyone's an individual. Everyone has their free will and has the ability to refuse services. We could put services in place for our client that we know would benefit them, but if they don't want to participate, we can't force them to participate. And so again, we're looking at everyone as an individual. So we work really hard to try and get them to comply or cooperate with things that are going to be beneficial for them, but they don't always do that. Sometimes too, it takes time. So as I mentioned, we're strangers to our clients. They go through this court process that I'm sure is invasive to them, that they don't understand. No one wants to be told or hear that you can't do something. And then here we are, we step in and say, hey, we're here to help, but they don't always look at it, right, as we're here to help. We're part of that court process. So I think they may sometimes look at us as, you're the person that's going to take over my life, and you're going to, not let me have a life, and you're going to make all these decisions. And so sometimes it's hard, or it takes some time to build that trust with a client, so they understand, that you're there for them, that you're trying to advocate for them. What we've seen is that, by the time a client gets to us, they've had so much trauma in their lives, and people are not consistent. Life is not stable for them. So, you think about someone who's 20, 30, 40, 50 years old that has had this trauma, and we walk in, they're not going to trust us right away. It's going to take some time for them to even understand why we're here. So sometimes that can also be an issue with a client being, engaged in services, and that's just something we work on with our clients over time. One other thing that I think people sometimes don't realize is that guardians cannot force medication, and we cannot force a mental health hold. Those are very specific court and statutory processes. So a guardian could initiate. So if there's a provider that says, their behaviors are too much escalating, and we think they'd be best served by forced medications, of course, depending on all the factors, if we agree with that, we would be agreeable and assist and things like that. But we can't walk in to a hospital or a facility and say, yes, make him take that medicine. Same for a mental health hold. We can help initiate and we can help with the process, but by law, a guardian cannot do those things without a court order. Some other kind of limitations to guardianship, of course, are limited funds for our clients. A lot of our clients, you know, are on some sort of Social Security benefit. They're on Medicaid, Medicare. They don't have funds, and that's one of the eligibility requirements for our program, which I'll talk about next, is we serve indigent adults. So, you know, imagine someone, I'm sure you've seen it, someone receives Social Security benefits of some sort, they're in a facility, most of that goes to the facility, they get like $91 a month for personal needs allowance. That doesn't, I mean, allow for very much, right? So, or even a person who is maybe still living in the community, again, they have limited funding. And so I think one thing people think about guardianship is, oh, well, now you're in charge of everything and now you're responsible for everything. So financially, by law, a guardian is not responsible for a client's financial obligations. So we can, you know, assist in paying rent or assist in, you know, getting things for the client, but we literally have no access to their funds. And we can't just kind of create funds. One thing I would like to do if we receive enough funding is to create a client fund so that we do have some extra funds for, you know, when our clients might need an emergency respite or need hygiene items, you know, even very basic things our clients don't always have. And unfortunately, we have to work within the systems. We don't just have funding to pay for our clients, you know, rent and things like that. So obviously that can be a real limitation for our clients. And then also community inefficiencies. And, you know, I'm sure you're aware of some of these, if not all of them. There isn't affordable housing for clients. There isn't funds to kind of, there are some programs that help assist clients to getting to an apartment or things like that, but you know, there are certain eligibility requirements, so it's not something that automatically is available for clients. And there's not always appropriate programming and services for clients out in the community. So, you know, every county is different. Every county has their own, you know, services, their own funding for services, and so that can be good and it can be bad. Sometimes I wish like, oh, I wish we had this funding program, you know, in Denver that they have in Aurora. And so, you know, sometimes there just aren't the services for our clients to really have the best quality of life. And so what we do as guardians is we just do our best to kind of think outside of the box and piecemeal services as best we can, and we're always updating our resources, always learning about new programs to help benefit our clients.
Sophia, we have a question here that asks, my understanding of the 72-hour hold process is that it is begun in an emergency situation. So how can the PG get an expedited court order for this to happen?
So there are, I'm trying to remember, I'd have to look back specifically. We would just work with the medical team in that emergency to get that person on a hold. We don't really do any of the legal paperwork for that. So we would rely on, I hope I'm answering the question. We would rely on the law enforcement officer if they're the ones that say a hold needs to take place, or we'd rely on the medical facility to do that paperwork to get the order. Now, we have worked a little bit with the Denver County, specifically Denver County mental health attorney, and we're kind of trying to work on ways that we could help more when a mental health hold is needed. But honestly, I don't think usually the clients so far we've had, they've already come to us with a long-term certification or a long-term medication, forced medication order. So we haven't really had to initiate any of those at this point. One other thing, if our program's expanded, is I'd like to have an attorney in-house counsel to assist with these legal proceedings. But at this point in time, we don't do that. Did I answer your question? I hope I did. Chime back in if I didn't, please. Okay, so moving on to eligibility. So these eligibility requirements are all by statute. So as I mentioned, someone has to be a resident of Denver County. I asterisk that because I try to work on different avenues to open up our services to individuals that may not be currently in Denver County. So as an example of what I mean by that, sometimes someone maybe had a connection to Denver County prior. Maybe they were homeless, but in Denver County. Maybe they got hospitalized because of an accident or something like that in a hospital outside of Denver County. So that is someone that I would still consider a resident of Denver County because they had that nexus to Denver County. And the goal is to discharge them back to Denver County. So whenever I'm talking with people about referrals, I always go through kind of the history to see, do they have any sort of nexus to Denver County so that we can try and get them into our program. So if you ever have a question about that residence issue, always please call me so we can talk about it. Outside of that, a resident of Denver County, they have to be an adult 21 years of age or older. They have to be indigent. And we use the Chief Justice Colorado directive of what indigency means. Basically, we follow the federal poverty guidelines when it comes to that. There can be some exceptions, you know, if someone has a trust or they might have a lot of funds at the moment, but they might need to be spent down for Medicaid to come into play. So, you know, if you're not sure on that indigency question, please again, reach out to me. Our individuals that we serve, of course, have to be incapacitated, have some sort of incapacity. And we don't limit what incapacities we serve. So currently we have individuals diagnosed with intellectual or developmental disability, cognitive impairments, which can range from a traumatic brain injury to dementia type diagnoses, individuals that may have severe or significant mental health issues can qualify, and also individuals that may have a substance use disorder. Again, the incapacity though always goes back to, but does that affect their ability to make safe and appropriate decisions for their health, safety, and welfare? And then we are the office of last resort. So that means someone doesn't have responsible family or friends that are available or appropriate to serve as guardian. You know, ideally, we're here to serve people that really have no one else. But we know, and the experience, of course, has been sometimes they do have family, but for many reasons, that family member is not appropriate or available to serve as guardian. So just because they have someone because they have family or friends, don't discount that they could still be eligible for a program, because it could be that that person just isn't appropriate to serve as guardian, or they just don't want to. And then some, I don't know what your experiences have been with adult protective services, but across the state, some county APSs can become guardian for individuals that meet their criteria of abuse, neglect, exploitation, mistreatment. We have a relationship with most APS county offices that definitely in Denver County, that if they don't qualify for exactly meet that criteria, but they think they're eligible for a guardian through the Office of Public Guardianship, they will refer that to our office. And so the reason that it's in statute, not the eligibility, that the person can't be subject to an APS guardianship petition, is because they don't want us overlapping guardianship services with APS. And in most counties, that's not an issue because most counties don't accept guardianships.
Sophia, speaking of the scope of your services and the division between counties, is there an expectation that the program would become statewide and not just Denver County at some point, or an effort to kind of I know funding is kind of the key issue, but is that possible, and when do you think that might happen?
Yeah. So 2 points to that. So one is that the purpose of that, of us gathering all this data, we have to gather the data statewide. It's not just Denver County. So that General Assembly report in January 2023, that's kind of our best way to say, General Assembly, there is this need across the state, and these counties, we can tell you, specifically the number of people that are unfriended, that go without guardian, or that there aren't guardianship services at all in those counties. So we'll talk a little more specifically about what goes into that report, but that's our ability to say, General Assembly, we need this across the state. Okay. So I think at the soonest it would be mid 2023 that there might be new legislation to expand our program. What I don't know, and we won't know until then, is if we'll get the funding to expand to certain counties, or if we'll be able to expand just statewide right out of the gate. So that's why we're collecting data. We're trying to collect data to show each county kind of what their needs are, so that if we only get funding for, to expand to 2 more counties, we can say, these are the 2 counties that have shown over this period of time, the greatest need. I obviously want it to go statewide. I'm going to do my best in that report to have the program go statewide. But on the flip side of that, if we're able to get any funding in between, like I said, we were able to get funding from the Office of Behavioral Health to hire another guardian. There's a chance we could expand into 1 more or 2 more counties if we're able to get some kind of funding not from the General Assembly prior to 2023. So that is something that I'm always trying to look at and see if we could possibly expand sooner than 2023. But I think realistically with funding, it wouldn't be prior to 2023.
Thank you.
Yep. All right, and moving along. So letting you know how to make a referral to our office. So we have a website, and I think Camille shared in the group chat our website. It's also in the slides if you need it after the fact. But what we do is, since we don't have legal counsel, we cannot file the court papers to initiate a guardianship. I am working right now on establishing a contract attorney or working with Medical Legal Partnership to be able to file those petitions for us, but that is pending. That hasn't gone through. So right now, if you want to nominate our office, you have to complete a referral online, and then you'll need to make sure you have legal counsel that's available to file for guardianship. So in order to do a referral, you have to go to our website and register 1 time. I'm going to try and show you the website. And my site, sorry, it looks kind of jumbled up because I'm actually looking at it through an admin view. But if you can see up here, these little tabs, a home, referral process, get involved, all these other ones. The referral process, if you go to that page, it kind of talks about the referral process and how that works. Here is the register button. You have to register one time. That's to create an account so that you have confidential access to the referral process so that you can upload referral documents. So that would mean financial documents, might mean some assessments or evaluations showing incapacity and things like that. Once you have your account, you can go in as many times to that and make as many referrals as you want. That also allows you to go back in after you've made a referral to update information or, you know, submit something and you can say, hey, I've got this medical record coming, I'll upload it as soon as I have it available. And it kind of walks you through how the court process, like we kind of talked about. So it's kind of a good little page if you want to kind of get more information about the process and our eligibility. Now, when you make a referral, we ask you a lot of information. And this down here, you can do the click menu and it kind of gives you just a touch of what information we're going to be asking for. I encourage anyone, if you're making a referral, go to our referral checklist and you can click here and it'll open it to you. I will send you a PDF of the referral checklist along with our slides so that you have that. I encourage someone to walk through this prior to submitting a referral, just so you can try and have as much information available as you complete the referral. We asked, I said, for a lot of information. Why do we ask for some of this information? So some of this information, of course, is to make sure that the person is eligible for our program. But we also ask information just so that we kind of have a better picture of the client. Because what I try to do is I try to match the client to a guardian that I think their personalities might fit, or you know, some guardian's background may fit this client better because they have more experience with homelessness and those issues, something like that. But we also ask so that as we are taking a case, we can just run, kind of pick up and run with it. So we do ask, you know, veteran status, we ask gender, all of those things. We ask if they have any pending criminal or other court proceedings. All of that extra information does not have a bearing on whether we accept a referral. So just because someone has criminal charges, that doesn't mean we're going to say, nope, no, we're not going to take that. This is for us to kind of get a full picture of the person that we may be serving. And, you know, so we know what issues are going to come up, what do we need to address, you know, as quickly as possible for our clients.
Sophia, one of the sections there inquires about family and friend availability. Yes. And there's an audience question that I think is relevant here. This person says, I had recent experience with an adult IDD client who was appointed a private guardian, no JDF relative affidavit, is there someone, family or friend, was generated to determine if there was an individual known to the client who could be an appropriate guardian. Do you have any ideas why that might not have been explored?
Yeah, so unfortunately, I think that's just sometimes a step that people don't want to do. You know, it's or they could have made a statement to the court that there is no family or friends, and the court, you know, depending on the court, may take that at, you know, at their word. And I'm not saying, you know, you should or shouldn't do, you know, say things to the court or whatever those things are. But even for us, for our program, we have to have people tell us, who did you contact? Who are you aware of? Of course, people, could misconstrue that. People could say, oh, there's no one. And we can't always verify that at the time. But I think one of the things we do once we're appointed is we seek out family and support people. So, and that happens to us more often than not, that we, the person, the ward, the client will be like, oh, I have a sister in Florida. Oh, okay. No one knew that. Or I mean, and it could be no one knew that. It could have been she didn't share that information. So that's one thing too that can happen. So people don't want to share, information with strangers. So, I want to say everyone's intentions are good. It could have been a situation that, they thought that was the case. There was no support, but, if you come if you find out later, same for us, if we find a family member and it's appropriate, we will let the court know, and we will say, hey, we think this person could be guardian instead of us, because family is always a priority guardian than us. So I would encourage you to maybe, if you have the opportunity in the next time, to say to the court, hey, I think there is family members. You can speak up and and kind of point that out. But on the back end, if you find out information, I think it's appropriate to let the current guardian know, that this person is available. Again, maybe they won't serve as guardian, but maybe they can still have a family relationship with that person.
Wonderful. Thank you.
I hope I answered that. Okay. All right. I was going to just add, if someone doesn't have access to the internet and can't do the online website, you can call our office, and our staff assistant, America, can help you do it over the phone. And I mean, you give America the verbal information and she will enter it in the online process. If you ever have a question, feel free to call me, email me, contact the office. We want to try and help this process be easy, but it's not an easy process, right? When you're talking about an individual and their needs. One other thing on the referral information, at the very end, there's a box that says additional information. What I encourage you to do is use that box to add anything that you think is important that wasn't asked on the referral. But also, we don't expect you to know 100% of the information on the referral. So I don't want you to be too daunted, by looking at the referral and say, oh my gosh, I have to have every single piece of this. Obviously, we prefer that, but we also know that, especially if you're a hospital, this may be the first contact you've ever had with an individual, right? And because of their incapacity, maybe you can't get answers about, do you have a checking account? Do you have benefits? All these other things. So I encourage you, fill out as much as you know and can find out. And then in that additional information box, you can let us know, this client, is new to us. This is all the information we have. And we might follow up with you and ask some clarifying questions, but it's okay if you don't know all the answers and have all the information. So kind of moving on to how we act as guardians, more specifically, once we've been appointed, there are standards and practices that the National Guardianship Association has established. This website and organization is the go-to for guardians. Oh, you know what? I should take a step back and mention, if someone wants to become guardian, that's not us, family or private, at this point in time in Colorado, there is no training requirements for a guardian. So to be a guardian, you have to be 21 and older. You have to have decent credit. You have to submit a credit report, and then you have to pass a background check to make sure there's no crimes against vulnerable populations, things like that. Other than that, you don't have to take a class. You don't have to be certified. You don't really have to do anything to be a guardian. And so I think, you know, that kind of poses an issue, especially for you all when you're trying to work with guardians. Every guardian probably does things very differently, right? And especially county to county, there are different kind of requirements as, that the courts can instill. A guardian, at a minimum, you know, should see their client. There's no requirement on how many times they see their client within a year, but a guardian does have to complete annual guardian reports to the court. And the court reviews that to make sure that, you know, the person is safe, that they should still be under guardianship or not. But other than that, there aren't really great standards or guidelines, okay, for guardians. So our office, what we're doing is we follow the National Guardianship Association standards, and that's because there's nothing standardized here in the state of Colorado. So there are standards for agencies and programs providing guardianship services, which we've adopted all of those into our policies and procedures. The NGA has ethical principles that's the next slide, so we can look at those for guardians to follow. And then there's just the general guardianship standards of practice to follow. So all of those we've adopted and incorporated into our organization and our systems and how we do things. And we'll talk a little bit more kind of how that looks. And then there is a national guardianship certification program that is through the Center for Guardianship Certification. And that website, you can actually search guardians nationally that have been certified. So there's two levels. There's the National Certified Guardian, and then the next level up is the National Master Guardian. To become certified, you have to take an exam and pass a background check and all those things. And then you have to continue taking continuing education to keep your certification up. And then to be a master guardian, you kind of have to do the same thing, take another exam and stay with continuing education. Our office, we're all in the process of going through to become national certified guardians. Camille Price, who's going to be presenting here in a couple of minutes, she is nationally certified. And we have another guardian, Rhonda Sanchez, who's nationally certified. I'm waiting for my some of my background check and things like that so that I can sit for the exam. So I hope to be nationally certified before the end of the summer. And I think it just lends real credence to our program to be certified and to follow the NGA standards. We want to serve as kind of that role model for guardians across the state. And one of the things that the local Colorado Bar Association elder law group, they're trying to standardize some of these certifications so that fiduciaries are trained and things like that. So I'm hoping that that's something that the state ends up doing, because I think that'll be very beneficial for anyone interacting with guardians, but also just guardianship services. Here's the slide with the NGA ethical principles. You know, I'm not going to read them all to you, but basically, you know, we have to, of course, treat our person with dignity, keep things confidential. We involve them in the decision making, all kinds of things like that. And so we do follow those, again, within our policies and procedures. I'm going to try and hurry on the last couple slides so that you can hear from Camille, because she has wonderful information. As far as those best practices, we do create an individualized guardianship plan for each client. That includes, you know, treatment, that includes their goals. With that, we use the person-centered or directed planning, and we consider least restrictive alternatives. We do this continually. We meet with our clients monthly. That's just an internal requirement. So every month, you know, if there's information to update that guardianship plan with, our guardians do that in working with the clients. And then, of course, part of the best practices is we, you know, use informed consent. Always we stand in the place of our person when we're receiving information about medical procedures or treatment. And then the standards for decision making, those two are established by the NGA. We want to know what our person wants for certain things. So we do the most form, we do 5 wishes with our clients so that hopefully we can make decisions that that mirror what they want. If we can't find that out, from the client, we go to support members, family members, anyone who has a history that can maybe give us some of that information. And so using that information, we try to make a decision, based on what we think they want. And then if we can't get that information, then we go to the best interest standard, which is actually the best interest standard is a statutory requirement, but we try to go above and beyond that. So I'm going to turn it over to Camille to talk about her client and stuff. I'm going to try to not stop sharing.
Good morning, everyone. I'm Camille Price, and I'm a public guardian with the Colorado Office of Public Guardianship. This morning, I'd like to share with you one of my cases to show you how impactful public guardianship support and advocacy has been for an at-risk and vulnerable person in our community. The case I'd like to share with you today is my client, whom I will refer to as John, which is not his real name. John's progress towards safety, health, and wellness has been extraordinary since receiving a public guardian in August of 2020. John is a 28-year-old man who had the diagnosis of pervasive developmental disorder. He was born in Denver and experienced lifelong difficulties with the symptoms of his condition, which included severe disruptive and assaultive behaviors. In his family home, John was considered to be dangerous to other children, and his parents became overwhelmed and unable to manage John's condition. Ultimately, John's behavioral difficulties were too much for his family to manage, and John was reported to have been turned over by his parents to child welfare services. John then spent the remainder of his childhood at the El Pueblo Boys Ranch. When John aged out of the child welfare system, he was left to live on his own. John's family had disconnected from him, and John was not provided with support services and was not able to maintain housing or stability and was homeless for the next several years. During these years, he had no support services to manage his medications, and he went in and out of emergency rooms and jails where his medications were changed constantly due to John's inability to advocate for himself, and this only worsened his behavioral symptoms. Due to his assaultive behaviors, John had been banned from all homeless shelters in Denver and had been evicted from several assisted living facilities. And despite being registered as a client in the human service agencies in Denver, John was not receiving appropriate services or support towards his safety, health, or well-being. On his own, John was vulnerable to predation and exploitation. He experienced sexual assault and was also hit by a car when he was walking alone in a parking lot at night. When he was hit by a car, he ended up in the hospital for several months, recovering from a traumatic brain injury while in a coma. John was completely unable to protect himself from the dangers of living on the streets. During John's homelessness, he accumulated numerous criminal charges ranging from theft, assault, to trespassing. He had numerous criminal cases in several different counties and accumulated thousands of dollars in court fees. Additionally, John was reported to have called 911 over 300 times in 2019. A caseworker from a social service agency submitted a referral to the Office of Public Guardianship on John's behalf after observing that many agencies had been unable to provide for John's safety, health, or well-being. After receiving the referral, I was designated as John's public guardian by the OPG director, Sophia Alvarez. The OPG referral process includes the petition, the notice of hearing, an order appointing a court visitor, a completed court visitor report, the order for court-appointed counsel, and the submission of medical documentation. As the designated public guardian, I met with John prior to the guardianship hearing to introduce myself and to answer any questions or address his concerns about guardianship. After the appointment, there's some initial steps that we take in guardianship. And these tasks include meeting with John within 10 days of the guardianship hearing, advising John of his rights and expectations, providing him with an OPG welcome packet and his guardianship documentation, completing John's initial guardianship investigation and checklist, completing his social history survey, assessing for the safety and health of John, and assessing his living environment, and then completing his person-centered, individualized guardianship plan. When I went out to meet John for the first time, I found him in a hotel on Colfax Avenue in Denver. He had recently been discharged from an involuntary hold from Centennial Hospital. When I entered John's hotel room, it was immediately evident that John was unable to manage living independently. As his public guardian, I was able to immediately take John to the hospital for a thorough physical examination. It was found that John was experiencing acute respiratory failure and diabetes that was not being treated. Without treatment, cardiac failure and/or diabetic coma or death were imminent. These health issues were addressed at the Stout Street Clinic, and John now receives ongoing regular assessments and treatment for his health conditions. Due to the lack of available housing services, I had to work to keep John as safe as possible while he was continuing to live at the hotel. I provided check-in calls throughout the day, in-person visits, and assisted John with medication management. As John's public guardian, I was able to have John complete an updated IQ assessment and neuropsychiatric assessment for the purpose of updating his diagnoses and treatment plan. John was given new diagnoses, which included autism, disruptive mood disorder, and post-traumatic stress disorder. With John's updated IQ assessment, I was able to have John gain his intellectual and developmental disability determination and to use this necessary determination to apply for an emergency developmental disability waiver. This waiver allows John to receive the necessary and appropriate services to support his health, safety, and wellness. While we were awaiting the approval of John's developmental disability waiver, I was able to use his disability determination to apply for and receive emergency mill levy funds. I was able to use these funds to pay for a respite home for John, and within a month of having a public guardian, John was placed in a host home in Denver. John now has the developmental disability waiver that covers his host home, behavioral counseling, and day services that he attends 3 times a week. John has now been in his host home for 9 months, and this is the longest period of stability and wellness that he has ever had in his life. His licensed and trained host home provider is providing 24/7 care, support, and supervision for John while teaching him valuable life skills in a family environment. While I was listening to Sophia's presentation, I was reminded that we had some bumps in the road when we initially placed him in the host home. John really wanted to go back to the hotel, so he made some police reports on me and the host home provider, and was calling everybody trying to get himself back into the hotel. But John is now, 9 months later, has found stability in his new home, and he refers to his home as his forever home. I've been able to work with John and his psychiatrist towards updating and modifying his medication regimen in accordance with John's updated diagnoses. This has resulted in John having improved health and a reduction in the uncomfortable side effects from his old medications that were no longer appropriate for his condition. As just John's public guardian, I've also been able to intervene in John's many criminal cases. I've connected him to public defenders in each county where he has cases, and at this point, I have advocated and succeeded and getting John's many cases dismissed, and I was able to get him off of probation in 2 counties. At this point, John has not had any new criminal charges since the appointment of a public guardian. John now reports that he loves his new home. In his host home, John is included in all activities and it is a family environment. John was included in Thanksgiving festivities, and he reported that it was the first time he could remember ever having a Thanksgiving dinner. He enjoyed the holidays and also spent Christmas with his host home family. Ongoing public guardianship tasks for John consist of continued monitoring of his services to ensure that his needs are being met. As his public guardian, I have a weekly check-in phone call with John that gives him the opportunity to share his updates and concerns. I also visit him at his residence once a month to assess for the continued safety of his environment. In conclusion, I'd like to express my gratitude to the OPG Commission, our director, Sophia Alvarez, and to the people of Denver for making public guardianship possible in Denver. I'm looking forward to continuing to serve at-risk and vulnerable people in our community. Thank you.
Thank you so much. What a success story. Thank you to Camille and Sophia. We have some time. I know there have been many great questions asked along the way, but I wonder if there are other questions that folks might have for Sophia or Camille.
And if not, I can talk a little bit about ways you might be able to help us gather some of that data.
I think that would be great, Sophia.
All right, yeah, and feel free again if you have questions, interrupt, please. I'm gonna try and share real quick. I just have like 3 slides left, I think, that I could share. So I talked about that director report. So what specifically needs to go into that report? As I mentioned, I have to quantify Colorado's, the whole state's unmet need for public guardianship services, quantify the average annual cost of providing guardianship services, quantify the net cost or benefit, if any, to the state that may result from the provision of guardianship services, identify any notable efficiencies and obstacles, which won't be difficult. And then there's also some assessments on whether it should be an independent statewide office like we have, or the current independent office that we have, or a nonprofit agency. And really just provide, overall information. Does our program provide a benefit to the state, not just to our clients? And so we're looking a lot at public safety offices, like here in Denver County. As Camille mentioned in her case study there, the client, excuse me, prior to our involvement, called 911 constantly for needs, excuse me, to have his needs met. He hasn't done that since Camille was appointed and has been working with him. So, in a way, that's saving those 911 calls and those officers to have to go out and see what the issues are. So I put this slide in. This was the best little picture I could find to say how we need you. We need your help in getting this data. And why? Because we want to expand statewide. As I mentioned, more data allows us to better assess the need. And so we can maybe strategically expand to those counties with the higher need. But also, I think our expansion allows for consistent and professional public guardianship services statewide. So you know who you're dealing with and how a guardian should act. So how can you do that? Again, submit your referrals to us in Denver County on that referral page. I do have a streamlined referral page for counties that are not Denver. It's on that same referral page. I'll show you here real quick. Referral process, non-Denver County constituents. That's to help us learn from other counties. You know, if you have a case that you think would be eligible for our services, we want to hear that from you. The referral for the streamline is very short and quick. You don't have to fill out all that information. And if you have questions on that, let me know. If you think your organization or you know, the hospital you work at, if you think they can help provide us with some of this data, especially the cost savings data, you know, how much does it cost to keep an individual in the hospital? You know, they can't be discharged until they have a guardian. How much money could the hospital or the state save if there was an available guardian to discharge that person? We will be having applications for a stakeholder advisory panel. That is, I think, would be so beneficial to have some outside of Denver County people on this panel. It's to basically hear what we're doing, see if we can do things better. More information on that I can provide you afterwards. And then also 2 other things that I'm excited about is we want to start a guardianship academy, and that would be for volunteer guardians that are willing to become guardian of individuals, but also potentially become guardian, successor guardian of our clients. So like this client that Camille talked about, John, you heard how he had really nothing set up for him, and we had to come in and help him get stabilized. He's stabilized. Maybe now or in the near future, since he has you know, a good stable life and he has his needs met, maybe now it would be a good idea to pass him on to a successor guardian. So, you know, the successor guardian can kind of maintain these services and his stability, so that can open up more availability for our office to take on another case who maybe, you know, has a similar situation that really needs our help. And then also on our website, you can sign up for the OPG Inside Look communication group. We send you notice of our monthly meetings. We would send you notice about that Guardianship Academy and the stakeholder advisory panel. That's just something if you want to kind of keep up to date on our progress and how we're doing. So any of these things that you think you may be interested in or could help with data, please feel free to reach out to me directly. This is the office phone. We have a general email for the office. You can use that. You saw our website, and then my email is there on the slide. Any questions, any, you know, concerns, any feedback, I'm open to it. So please reach out to me if you have any questions.
Sophia, there is a question about immigration status and with Governor Polis's mandate to not disclose unless required by law. How does that impact you know, your intake and process?
Oh, that's a good question. We have had, I think, just maybe 2 referrals so far that we're aware of some. So immigration status for our eligibility does not matter. Okay, so you don't have to disclose their citizenship status or anything like that to us during the referral process. What usually ends up happening is after we're appointed, then we, you know, learn about it, you know, if someone needs to have their immigration paperwork updated or apply or things like that. So it hasn't been an issue really so far, but I could, you know, if that's an issue or hesitancy, that's something I can think about changing on our referral form. Okay, thank you.
Are there other questions for Sophia or Camille? And I really appreciate you sharing those, you know, ways that folks can, you know, really become involved, and especially with the gathering of data. And another comment here is that, you know, substance use disorder info might also be something that's, you know, uncomfortable for people to provide.
Got it. Thank you. Okay, yeah, I can definitely, I just saw the comment about maybe that and the immigration status, making that optional. So yeah, that's definitely something I think we can do.
Thank you everyone for your comments and your questions. We have a few minutes here if you have any further questions. As I mentioned, the presentation will also be available sometime in the next, you know, few weeks on our website. So, you know, it's so packed with information and resources. I hope that you can avail yourself of that information as well. I want to thank, of course, Sophia and Camille for your time today. Certainly learned so much, and what a beautiful story that we had there at the end. Camille, thank you. I also want to thank Amanda Hine, who is a board member of Chef and worked with Sophia and Camille to have you here today, as well as Steph Rieger, who is in charge of our different marketing events. And again, we you know, are trying to offer you know, these types of events every other month. So we would love to hear from you if there's events that you think would be helpful, and to see you for future events. We will be sharing the PowerPoint, I believe, as well, Sophia, if that works. It looks like there's interest for receiving those and being able to access those. Thank you all so much. I'll stay on here for a few more minutes if there's no further questions.
Can I jump in? I just
Yes, please.
saw someone asking, is guardianship similar to conservatorship?
Oh, that's a good question.
Yeah, so I will just real quickly, they're different, and especially here in Colorado, they like for those duties to be separate. So they don't want a guardian to also be a conservator. In Nebraska, we could be both.
Mm-hmm.
So guardianship means the person. So any decisions related to kind of housing, medical, things like that that are related individually to the person, that usually falls under guardianship. Conservatorship, that would mean the estate. So if someone has a lot of assets, checking accounts, stocks, bonds, and they lack the capacity to kind of handle all that housing, and if they have a house, vehicles, you know, stuff like that, their estate, a conservator is put in place to help manage the estate. So we bifurcate those here in Colorado. So those are very different. The information that the court uses to determine if someone needs a conservatorship is typically the same type of information they would use in determining whether someone's incapacitated and needs a conservator, similar to the information used in a guardianship case.
In your experience, Sophia, since you've worked in Nebraska, which allows for those two functions to be coupled, and then here where they're bifurcated, is there a model that you think works a little bit better in terms of the needs of clients?
You know, it's so hard. Actually, Camille and I were just talking about that recently. It's good and bad both ways, right? It's like anything else. Being a conservator of some, I mean, that can be a lot of work, you know, and just a lot of like paperwork and kind of the managing of that stuff. And then, you know, it impedes, in my opinion, a lot on being able to serve the individual needs of your client, right? Because you want to know, what does your client want for, you know, a medical treatment or something like that. So you really need to get to know your person. And so sometimes it's hard to do both when you're one person. But, you know, on some level, you know, we then have to work with a third party to, like, hey, our client needs clothes, you know, our client wants a tablet, you know, and so sometimes, you know, we need to make sure our client has their rent paid. You know, sometimes there's just a lot of logistics into that, and it feels really kind of slow to, you know, whereas, you know, we're like, well, we know they need that. Why don't we just go get them the tablet, you know? So yeah, it's good and bad. I think ideal would be we have the ability to do it, but we have like another financial person who's able to handle those duties so that the guardian can really focus on the individual in there. If we get funding, that's something I'd love to do.
Thank you.
I want to say thank you to everyone who attended. I'm so glad that you found it helpful and I appreciate the sentiments. I see some that, you know, you would really like this program in the Western Slope. So yeah, I think I took your names down. So maybe I can ask Kayla for your emails and contact you directly and see if we can kind of help get it expanded out there. I appreciate everybody's time. Thank you.